Hello, everyone, and welcome to Module C, the legal liability chapter. And one question that students have had in the past is why do we start with legal liability? And I think that anytime that you teach auditing, legal liability is something that should come up immediately in terms of your conversation about what auditors are doing and, more importantly, why are they doing it? So if we think about the audit risk model, for example, audit risk can be conceptualized as the auditor's business risk, which is very strongly correlated with their legal liability risk. And so a lot of what drives how auditors do things and why auditors do things is driven by legal liability, particularly in the United States. So I think it's an important thing to talk about up front because a lot of other things just fall out of an auditor's legal liability. So we're going to start off by just talking generally about legal concepts. So a lot of these terms you guys may have heard before, and so now we're just using them in the context of auditing. So the legal environment for an auditor. So what's going on with auditors? Well, we have some company, and there's a company out there, and they are ultimately run by a board of directors and management. And they're trying to communicate some information to a third party through their financial statements. And this could be the government, this could be labor unions, typically investors, but it can also be creditors, it could be a whole lot of people. But they're trying to convey information to through the financial statements. And the problem ends up being is that these third-party users want to be able to rely on the audited financial statements to make economic decisions, but they have a little bit of trouble placing, credibility in the financial statements because they know that the client firm or the management of the firm that's preparing the financial statements has an incentive to misrepresent what's actually occurred. And so, because of that, we need an auditor, right? So that's all an auditor is doing is they're lending credibility to the financial statements by, performing an audit, right? So performing some service that we have with the client. So we see a couple of things that come out of this relationship, and it's kind of an unusual relationship if you really step back and you think about it. The auditor is supposed to be working on behalf of the third party, but they're hired and their contract is with the company that's actually preparing the financial statements. So that creates a number of tensions and kind of uh, possibilities for things to go wrong in this environment because we are now bound by contract to do certain things for a client. And some people would say, well, you also may feel a little bit beholden to the client because they're the ones that are actually paying you. But we're actually supposed to be working for the third party uh, users of the financial statements theoretically. And so our job is to conduct a generally accepted auditing standards audit and ultimately issue an auditor's report that's going to accompany the company's financial statements and hopefully lend credibility to those financial statements. Now, we're not going to do that for free. This isn't UNICEF. So the company is going to pay us money. Um, and ultimately, we're going to be working a lot with the company's management. So the company's management are the ones that are going to create the financial statements, and we're going to be working hand in hand with them when we're performing our gas audit. But ultimately, they're not the ones that are in charge of the company, right? The board of directors are in charge. And so there's an interesting relationship there as well, because within the company, there can be a struggle between the board of directors and the management of the company. And while we're going to be working day to day more with the management, ultimately we report to the board of directors. So there's even some interplay within the different levels of the organization. So ignoring even the third party users of the financial statements, there can be issues between the auditor, the client's management, and the board of directors. So as the auditor, we find something unusual and we want to make sure and tell the board of directors, well, management may not be happy with that, right? Because it makes it look like they're not doing their job. Uh, and ultimately, management is going to have a big say in whether we get retained as the auditor. So there's some tensions even within the company in terms of the interplay of behavior between the auditor and the client firm. And so there are all these relationships that are going on. There are relationships between uh, the client and the third parties, and there's relationships between the third party and the auditor. In particular, when we think about these red lines and we think about the relationship between the third party and the auditor, what we're going to be talking about in this chapter is, okay, what liability do auditors have to third parties? If you think about most services that you would perform for someone, you don't have any liability really to people that you're not performing the service for. If you give someone a massage, you don't have liability to the person you're giving a massages to's husband, right? It's just to the person that you perform the service for. And so, this idea that we can potentially have liability with someone who we don't even know, who is not a party to the contract, is kind of a unique thing when we think about auditors. And so, there is potential liability relationships between the third parties and the client firm itself, right? Third parties can bring suit for misrepresented financial statements against the client. They can also bring that same suit against us. They can they can sue us both and say, "Hey, we want to collect money because these financial statements were materially misstated and this auditor's report is garbage that accompanied the financial statements because these financial statements are materially misrepresented." The client can also sue us, right? The client can sue us and say, "Hey, you didn't perform the job that you agreed to do." So contract law is a consideration. So there are a lot of dynamics that can exist in this seemingly basic relationship in terms of what we're actually doing. All we're doing is performing a gas audit. But in doing so, we have a lot of potential liability. We have potential liability to the client under contract law. We have potential liability to the client under tort law. We have potential liability to third parties under tort law. We have potential liability to clients or to third parties under federal securities laws, as well as state laws. So there are a lot of different layers and potential liabilities that we need to consider as the auditor. So what we're going to talk about in this chapter is who does the auditor actually have liability to in terms of performing the service. And so we're going to have liability to clients under contract law and common law, as well as statutory law. We're going to have liability to third parties under common law and under statutory law. And then we're going to end the chapter by talking about criminal liability and the potential for an auditor to actually face jail time if they are involved in materially misstated financial statements. So, a lot of different sources of liability for an audit. So, let's talk about some legal concepts, and some of these you may have heard, some of them you may not have. First one is deep pockets theory. And this is the concept that lawsuits may be brought against the auditors not because you did something wrong, but because you're the only one left to be sued. And so if you think about a company failing, right, that's when lawsuits are going to happen. People don't bring lawsuits when a company is doing great. It's only when the company starts losing money or is completely gone that lawsuits occur. And so if you think about the example of a company failing, so the company is no longer around, there are no assets to be taken uh, by the potential creditors, and this is in both investors and creditors potentially that are suing. And so you look around and you say, well, where can we recoup some of this money if you're the person that lost money? And the only one left standing is going to be the auditor. The company's gone, the assets are gone. But the auditor does have this indirect relationship with the client. And you can argue that, hey, I could have gotten out of this investment had the auditor done their job and reported that the company wasn't doing well. I would have made a different investment decision, or I would have made a different lending decision to that company had the financial statements not been materially misstated. And it's their negligence. They didn't do a good job. They didn't alert everyone. Uh, and so I'm going to sue them. These lawsuits are going to happen, right? Because it's, especially if you think about a class action type of lawsuit, there's not a lot to be lost by the people bringing the suit. Really, the risk there is borne by the people that the lawyers are actually filing the lawsuit. And so these lawsuits are going to occur for an auditor. If you're involved with a company and the company fails, someone's going to sue you. And that's just a fact of business. That's just part of being an auditor. And it's not because necessarily you did something wrong. It's because you're the only one left with any assets or any way to recoup their investment once the company has failed. So that's the deep pockets theory. And it drives a lot of what goes on in the auditing profession. Another concept that affects the auditing profession is this idea of the expectations gap. And this is the difference between essentially what the public thinks auditors do and what we actually do. So when you guys took your first class in auditing, if you guys have taken an undergraduate auditing course, one of the things you may have been struck by, and you probably should have been struck by, is how different auditing actually works in comparison to what you thought it was going in. When I initially heard about auditing or understood what auditing was, I thought that auditors went in and they checked everything. They found anything that was wrong and they fixed it. And so what they were saying is the financial statements are exactly the way that they should be. And in general, the public believes that that's what an audit report is saying. You're looking at everything and you're fixing everything and it's accurate. But the actual wording, when you read an auditor's report, is not that. It's saying that the financial statements are free of material misstatements. So we're not even saying that there aren't any misstatements. We're saying that there may be misstatements, but they're not material misstatements. And what's more than that, we're not providing absolute assurance. We're not saying that we're absolutely sure that there aren't any material misstatements. We're only providing reasonable assurance that there are no material. So that's very different from saying we're providing absolute assurance that there are no errors or fraud going on. And how this manifests itself in terms of legal liability is auditors and their lawyers are reluctant to want to go to trial because they understand that there is this expectations gap that they have to get over. That when they go to court and you're sitting there with 12 people that do not have a background in accounting and do not understand the nuance of an auditor's report and the difference between reasonable assurance and absolute assurance, and you try to explain to them what those differences are, their eyes glaze over and they say, you know what, they just didn't do their job. They should have found that. And so it drives a lot of decisions in terms of audit firms just saying, you know what, let's just settle this lawsuit. We know that we didn't do anything wrong, going back to the deep pockets theory, but why fight it? If we take this to trial, a jury's not going to understand. And so the expectations gap is important. And the truth of the matter is, it's unlikely that the public is going to come down to our understanding of what uh, we should be doing. And what you've seen over time is an uptick in the amount of work and the amount of assurance that essentially we're really providing. And so it's really going to be up to the profession to narrow that gap, because the idea that we're going to somehow educate the public down to what we're actually doing is highly unlikely. Prudent person concept. This is just the idea that we cannot be perfect as auditors. We're humans, and we have to make certain decisions in terms of performing an audit. One of the things that's important for students to remember is that this is a business. So while there's a regulatory part of it and a compliance part of what we're doing in terms of we have to do certain things, we also have to keep in mind that it's a business. And we can't do unlimited procedures and look at unlimited things. We have to do a reasonable job of trying to make sure that we're doing what other auditors would do in similar circumstances. But it's this idea that if we are following generally accepted auditing standards, uh, then we should be okay in terms of our own liability, because we cannot do a perfect job. And there are always going to be things, given how auditing procedures are actually conducted, there are always going to be things that are going to slip by us. Okay, so liability for acts of others. This is important for you guys to understand. Is an auditor liable for something that someone else did? And the answer is yes. So the auditor is liable for those under their direct supervision. So this includes employees. So if I'm the partner in an accounting firm, all those people that work underneath me, from the managers to the seniors to the staff accountants, I'm liable for their behavior. So I can't simply say, well, you know what? This staff auditor said that they did this and they didn't do this, so it's not my fault, it's their fault, so I'm not liable. No, they're under your supervision, so you're liable if they didn't do something that they said that they did. If you rely on work of other CPA firms, so you guys may remember from the audit reports that you can, if you're thinking about component auditors, you can rely on the work of other auditors. If you choose to do that, you're liable if they miss something. So if they say that they looked at something and they didn't, as it turns out, someone can come back and sue you. And similarly, specialists, if we hire someone to value inventory and they don't do a good job, we're liable for them as well. So anyone who's under your supervision, you are liable for lapses that they may make. Privileged communication. So this is one of my favorite topics, just because I always wanted to be a lawyer and I was never able to be one. But my favorite television show when I was a kid was Law and Order, the original one, not that creepy SVU stuff. So one, if you watch lawyer shows like that, you've probably heard of this idea of privileged communication. And privileged communication is just this idea that you cannot be compelled in court to testify about certain information. So the big ones are doctor patient. So you cannot force a doctor to testify against a patient in court. Uh, there is clergy and like clergy privilege. So if you go and confess to you know in church, the priest cannot be compelled to testify and tell in court what you said to them during that. And that's you know we can talk a lot about why these different privileges exist, but there are these certain privilege communications that you can have. Spousal privilege, cannot be compelled to testify against your spouse. There's a few, those are the big ones. And uh, auditors, and not just auditors, but accountants have privileged communication as well. And in particular, states grant privilege. This is state law. This is not federal law. So certain states have privileged communication. There are very few states left that have privileged communication for accountants. But in those states that do allow it, there is this privilege. Now, it's nothing like doctor-patient privilege, okay, which is universal. This state-granted privilege has several limitations. One of them is if you're required to report something by professional standards. So when we get into, I believe it is Module B, we're going to talk about professional responsibilities. And there are certain things that you have to report according to the AICPA professional standards. If the professional standards say you need to report it, you need to report it. It doesn't matter whether it was privileged communication. If you're subpoenaed or summoned, so meaning if you get a legal document from a court saying that you need to show up and testify to something, you have to say what occurred. So this is a giant limitation, right? So what this is basically saying is if you're called into court and you are forced to testify, you have to say what happened. So you can't just say, oh no, that was privileged communication. I don't want to talk about it. But it's important that it has to actually be a subpoena or a summons. It can't be, like I said, law and order. If you ever watch Law and Order, they go into some place, they go into a doctor's office and they say, we need this information about this patient. And go, oh, we can't say that because of doctor-patient privilege. And they say, well, okay. Well, what we're going to do is we're going to come in here and we're going to do this and we're going to do that and we're going to shut down your business and yada yada yada. And they say, okay, I'll give it to you. That's not a subpoena or summons. So threats under duress are not subpoena or summons. It has to be a valid court order subpoena or summons. Similarly, if there's some kind of ethics inquiry or investigation by the AICPA or a related state board, and they're asking you about something related to that client, you can't say, well, I can't give you that information because it's privileged communication. It's client information. I don't want to give it to you. You have to. And similarly, peer review. If you're part of peer review for a state, and part of that peer review is that they have to go through your client records. You can't, as part of that, use client privilege to say why you won't turn over certain documents to the peer reviewer. There's additional limitations. One, and this is very important, the intent at the time of the communication was that it was supposed to be confidential information, meaning the client has to specifically say, hey, by the way, I want this to remain confidential. It can't just be a general conversation that you're having with a client. They have to very specifically state that they want this to remain confidential. And lastly, because it's a state right, state law does not usurp federal law. And so state granted privilege does not extend to federal courts. So if you're in the federal court system, you cannot use a state privilege to say why you're not going to testify to something. It just won't work because it does not extend to federal courts. So that is privileged communication. We have it, but it's not very good. Okay, so some other legal terms that I want you guys to be familiar with. First, we have ordinary negligence. And this is just absence of reasonable care. So looking back to that prudent person concept, this is you're just not doing what a reasonable auditor would do in similar circumstances. The next level up from that or I guess you could say down, is gross negligence, which is lack of even slight care, which is tantamount to reckless behavior. So when we think about gross negligence, the term that you should associate with gross negligence is recklessness, right? It's reckless behavior. So what would be the distinction between these two? So ordinary negligence might be that there was a problem with accounts receivable, and you sent out confirmations, but someone's arguing, oh, you only sent out 10 confirmations and you should have sent out 100 confirmations. That might be an ordinary negligence type of issue. Gross negligence would be something like, I didn't even send out accounts receivable confirmations. Or, I had a student from the local university send out confirmations and, look at all of the assets, and I didn't give them any training and I didn't supervise them, and they just told me whether they thought it was good or it wasn't good. Right? That would be pretty reckless, right? They don't have enough training, you're not supervising them. That's reckless type of behavior. Constructive fraud is, in most states and in most interpretations of the law, identical to gross negligence. So, for the purposes of this class, we're going to use the terms gross negligence and constructive fraud synonymously. They mean the same thing. So, again, it's recklessness. Uh, and so, this is a situation where you're not trying to deceive people, but because you've done such a bad job, you wouldn't know if something was wrong or not. So it wasn't even that you necessarily had an intent to deceive people, but you did such a bad job that you would never know whether there was an issue to begin with. So this is the same idea. It's being reckless. And so what throws students off with this term is this term fraud. They think constructive fraud, that means fraud. It's not fraud. It's recklessness. So don't let that throw you off. Fraud is different. The difference between fraud and gross negligence and constructive fraud is this idea of intent. So fraud occurs when a misstatement is made with both a knowledge that there's an issue and there's an intent to deceive. So intent is very important in terms of distinguishing fraud from constructive fraud or gross negligence. Breach of contract. That's just not fulfilling the terms of contract. Pretty simple. And another term related to that, parties who have a contractual relationship are said to have privity of contract. So if you hear the term privity, that's what they're talking about. Third party beneficiaries. This is a third party who does not have privity of contract. So they do not have a contract with the auditor but, or the parties contracting, but they are known to the parties who are contracting. And they know that, uh, that is, the parties to the contract know that they're intended to be, to somehow benefit from the contractual relationship of the parties that do have privity of contract. So what's the example? An example would be if a client comes to us and says, hey, I'm trying to get this loan from Bank of America. Could you audit my financial statements? Bank of America is the third party beneficiary because they're the ones that are going to get this information, and you know that they're the ones that are going to get the information and use the information, even though they're not a party to the contract. A couple other terms, joint and several liability. This is just the idea that if you're sued, people can collect everything from you. So joint and several liability comes in a situation where people are suing a bunch of different people, right? So let's say that you're being sued by a bunch of investors who were defrauded by your client, and so they're suing the client, they're suing you, they're suing the CEO and the CFO individually, they're suing all these different people. Joint and several liability is the idea that you can potentially, if found culpable, you can potentially have to pay the full amount of what they're suing for. If you're found joint and severally liable, they can collect it all from you, even if you had almost no fault in the situation. Even if your part of the fraud was just that you didn't uncover the fraud and you really were kind of tangential to what was going on, they can potentially collect all of the money from you. And that's different from proportionate liability, which puts limitations on how much money people can collect from you, and it limits it to the proportion of how liable you were. Uh, and so, in terms of an auditor, you would much rather have proportionate liability, where there's going to be a limitation on how much you may have to pay, as opposed to joint and several, where you may potentially have to pay everything. So, what are the sources of auditor liability? Well, there's common law. And common law, remember back, that's using legal precedent, so using court cases to determine how the law evolves over time. And you have common law liability to clients and to non-shareholder third parties. And then you have statutory law. And so these are laws that are created by governmental entities, so SEC, Congress, state law, these kind of things. And these are violation of written statutes as opposed to some kind of common law that's been created by precedent. And when we think about statutory liability, we're thinking primarily about liability to shareholders. But if we move to look at just common law, we have breach of contract, which we've already said is just the failure to fulfill elements of the contract. And we have tort liability, which is an obligation based on a failure to exercise an appropriate level of professional care. And tort liability is going to really rely on those definitions that we just went over just a second ago. These negligence, gross negligence, and fraud. These, what you're going to be liable for is going to depend on the level of care that you uh, were found to either exert or not exert, I guess you could say. Meaning, there are certain things and in certain situations, we will not be liable if all that occurred was ordinary negligence. But in most cases, if we're involved in fraud, we're going to be liable to anyone who was hurt by that fraud. And so, in terms of looking at tort liability, it's very important what level people are asserting that we where we fall, right? So again, ordinary negligence being a lack of reasonable care, gross negligence being recklessness, and fraud being a misrepresentation of the fact an individual knows to be false. Because what we are liable for goes up at each level. We're much more liable for recklessness than we would be for ordinary negligence. And we're certainly much more liable for fraud than we would be under ordinary negligence. Another term, as long as we're introducing terms, that you probably have heard is this idea of scienter, which is just intent. That's what scienter is the intent to deceive. So let's go through some examples of some of these terms and apply some of these terms to some actual situations. So this first one, KPRV LLP, a CPA firm, provided audit services to AP&P, in which they relied on the work of Toiled LLP, another CPA firm, regarding the internal controls of a third-party payment processor, PayRight. Material fraud was later uncovered, which was directly related to PayRight's internal controls. Which of the following is or are true? And so we look at these and we say, okay, well, there's a lot of abbreviations here, so that's a little bit difficult. But the correct answer for this one is going to be that Toiled may be liable for losses caused by their failure to uncover the fraud. Keyword there being may. So if we look at the other ones and say, well, why aren't these other ones correct? A is not correct because it says they are liable. And we don't know. They may be liable. It depends. Were they negligent? Were they reckless? There's not enough information to really tell. C is wrong because it's saying they're not. So, you know, that's not a good answer because they may be. We don't know. And then obviously it can't be all of those. If one of them is saying they absolutely are, and the other one's saying they absolutely aren't. And this is an important thing as you guys are getting ready for the CPA exam to think about. When you guys are taking the audit portion of the CPA exam, words are all important. And so one of the things you need to look for if you're trying to eliminate potential answer choices are answers where something makes it, it say more than it should. So you're looking for words like always, never. Those kind of words are usually a good indication that it's not the correct answer. And so in this case, A and C are just saying too much. And B is kind of right there in the middle, where it's kind of saying, well, okay, it sounds like they're involved with these financial statements. They may be liable, but I'm not sure. Looking at some of these legal terms, let's see if we can match some of these things. So, failure of one or both parties to fulfill the requirements of a contract. And that should be breach of contract, but I don't see that as one of the terms. So the answer should be none of the above. Recklessness. So we say, okay, we should associate recklessness with gross negligence and constructive fraud. I do not see gross negligence or constructive fraud. So again, the answer would be none of the above. C, parties who share a contractual relationship. We said that was privity, so that should be 6. Laws passed by Congress or governmental entities, that would be statutory law. The assessment of a full loss suffered by a plaintiff, irrespective of shared wrongdoing, that would be joint and several liability, which is not there, so that would be none of the above. And F, knowledge of a material misstatement with intent to deceive. That would be fraud. And the intent to deceive, so one of the things people want to do is they see that intent to deceive and they want to uh, pick scienter. So the intent part is the scienter, but the knowledge and the intent are fraud. So important thing to take away from this question. One, when you guys take an exam from me, none of the above is going to be an appropriate answer a lot of times. And so don't be afraid to pick it. But similarly, don't be lazy in terms of memorizing what these terms mean. It's important that you understand that joint and several liability is different than separate and proportionate liability. And you need to understand what both of those definitions are. And if you're just looking for liability and you're going to try and match it that way, you may get the question wrong on the exam. The distinction between constructive fraud and fraud is that fraud has a greater degree of recklessness. And that sounds like it could be right, but it is actually false. Right? The primary distinction between fraud and constructive fraud is intent. And one, you have an intent to deceive. At a confidential meeting, an audit client informed a CPA about a client's illegal insider trading actions. A year later, the CPA was subpoenaed to appear in federal court to testify in a criminal trial against the client. The CPA was asked to testify to the meeting between the CPA and the client. After receiving immunity, the CPA should do which of the following? And the answer is what? You say, well, they should just discuss everything that happened. You say, well, wait a minute. I thought that they had, privileged communication. A couple of reasons why they don't have privileged communication. One, they were subpoenaed. That's a limitation. Also, it's in federal court. State granted privilege does not extend to federal court. So make sure that you know what those other limitations are, because I do a lot of derivations of this question. One where it's in state court, they're just choosing to testify. One where it's just a meeting, it's not a confidential meeting. So make sure you know all of those limitations related to privileged communication. The concept that the auditor is expected to conduct the audit with due care and is not expected to be perfect is the prudent person concept. And that is it for the lecture as far as the concepts. So there was a lot that we talked about, a lot to take in. And we will move on to learning objective two. So that's it for learning objective.